Question 51. What if I want to keep some non-exempt assets? Well, in most cases, you can buy those back from the trustee. Question 52. If I change my mind after filing, can I stop the bankruptcy? Only the judge can decide if you may dismiss your case or not. And even if you get your case dismissed, your credit report will still show that you did file a petition in bankruptcy. Question 53. What does it mean when a trustee abandons property? When the liquidation value of an asset cannot pay off the secured creditors, the trustee abandons it or simply gives it back to the debtor. Although you have been discharged from the obligation, if a workout cannot be achieved or payments made, you probably lose the property at a foreclosure. Question number 54. I thought bankruptcy stopped foreclosure. Can they still take my house? When you file bankruptcy, you will receive an automatic stay. When you file bankruptcy, you receive an automatic stay on court actions such as foreclosures and share sales. A creditor can still go into court and ask the bankruptcy judge for a relief from stay, and if granted, the creditor can proceed with court action to foreclose. Question 55. Can I change from a Chapter 13 to a Chapter 7 or vice versa later? Yes, it's called a motion to convert and can be done after you have filed for either chapter. Be advised that the trustee can also request a conversion. For example, if your Chapter 13 fails, either you or the creditor may request a conversion to Chapter 7. Likewise, if the trustee thinks money might be available for unsecured creditors, they may make a motion to convert your case from Chapter 7 to Chapter 13. Okay, continuing on with the 101 most frequently asked questions in bankruptcy, we now go to question number 56. What if I run out of exemptions, but I still want to keep some items? Well, after all of your exemptions have been exhausted, you may still be able to buy back some of your items from your trustee. Question number 57. What debts cannot be discharged in bankruptcy? Well, in general, spousal and child support, most student loans, secured debts, fines and penalties imposed by government agencies, debts incurred due to false statements made with the intent to deceive, fraud committed in a fiduciary capacity such as embezzlement or larceny, punitive damage claims for willful and malicious acts, debts not listed on the forms and schedules filed with the bankruptcy court, drunk driving obligations, and basically a non-dischargeable debt is one that will survive the bankruptcy proceeding. The debtor still has the obligation to pay this debt, and the creditor would have every right to collect that debt. Question 58. I heard that I have to take some kind of a course before filing. Is that true? Yes, under the law that was passed in 2005, credit counseling is a mandatory requirement. You must complete a pre-bankruptcy credit counseling course within 180 days of filing your bankruptcy petition. And you must use a service that has been approved by the U.S. Trustee's Office. There is further information about that in the Bankruptcy Guide. Question 59. Are there two courses I have to take, or is it just one course? Well, the answer to that is there really are two courses that you have to take during the process. After you file, and within 45 days after the first date set for your creditors meeting, you must complete a course on financial management. When you complete the course, you must file something called a Form 23 with the bankruptcy court, which simply informs the court that you have completed your second course. Question number 60. What happens at a 341 meeting? Well, soon after you file your petition, you'll get a notice to appear for a creditors meeting, which is sometimes called a 341 meeting. This will probably be the only time you will need to make an actual personal appearance. At this meeting, which is held with the trustee and any interested creditors, you'll be sworn in, and the trustee will ask you questions about your petition and schedules. Creditors also have a chance to ask questions, although frequently no creditors appear at those meetings, because if there are no assets to collect, the creditors don't waste their time showing up.